Labour law experts have called for emergency regulations on amendments to be put in place in the event of employees possibly becoming infected with the coronavirus, COVID-19. And there are also confirmed cases of COVID-19 in South Africa, a couple from KwaZulu-Natal, as you've just heard. Actually, let's chat a little bit more about this in studio with Puke Maserumule, there we go, attorney and a founder of your firm. Thanks so much indeed for joining us. All right, so this is an interesting scenario that's playing out where we have people who have to go into self-isolation or self-quarantine. They don't want to be in quarantine and isolation. What do the employers do?
And that's the big question, because our law recognizes, for example, someone who's sick and is off sick. So they get sick leave and they get paid for not being at work. Or you take annual leave because you want to go and rest. You get paid for being on annual leave. The issue here now is not so much the people who get sick. Is if you are in a workplace like this, somebody gets infected and 10, 20 of you must stay away just in case they have been infected, just in case they might infect others. Now, you are not sick, so you can't get paid on the basis that you're on sick leave. But you're not on annual leave either, so you can't get paid on the basis that you're on annual leave. And the big question, of course, is then who becomes liable to make the payment? The employer says, but I haven't asked you to stay at home. You have to stay at home because of circumstances completely beyond my control. Now, generally in the law of contract, for example, you have events which are called supervening impossibility of performance, where it becomes impossible for either party to perform. This could be one of those. And because the law doesn't really cover those who are not ill and those who are not on annual leave, and because you can't claim from the compensation fund, because you don't have a disease yourself, you may have, but you don't know. You can't claim from unemployment insurance fund because you are not unemployed. Your employment has not been terminated. So the question really is for employers, what do you do? How do you pay these people? If you don't have insurance cover, for example, for interruption to your business, how do you deal with this situation? And the way I see it is it may well be that something like the UIF, you could have an amendment either to the Act or regulations could be issued to enable, if we have a large-scale problem, employees to be paid, but not at the expense of employers who may not be trading.
So what should an employer do in the interim, and an employee? Because he may lose out. Somebody's going to lose out one way or the other. That we know for certain. Is it likely that the employer probably is in a better position to be the one losing out than the employee?
If you look at it, both parties probably may well be in the same position, because particularly with smaller employers, they may not be able to have the resources to, for 2 or 3 weeks pay employees who are actually not working. Their businesses may well close down. But at the same time, and a mid-level or junior employee who doesn't come to work and doesn't get paid for 2 weeks may not be able to feed the family, may not be able to pay the rental. And the employer would say, but in terms of the health situation, government says you shouldn't be at work. So I haven't asked you not to come to work. Right. The employee hasn't asked not to come to work, and that becomes the dilemma.
So you mentioned the law of contract, and I guess where it becomes impossible to perform, you should be put in the position you were before the contract came into being, so that all bets are off, no one pays the other, but the employee loses out on a day of wages, isn't he?
The employee loses. I mean, if you look at it, in employment law, for example, your obligation as an employee is to tender your services to the employer, and then the employer must pay you even if the employer doesn't accept the tender. So the big question is, if I'm asked to self-isolate, I'm therefore unable to tender my services because I can't do that. I can't say to you I'm coming to work tomorrow, because in terms of the the health situation, I can't be at work.
So what if I say, look, I can't afford not to come to work. I know I should be self-isolating. I'm going to come to work. Can I rather work on my own?
Well, certainly working from home is an option depending on the nature of the business. So if you have connectivity, for example, the employer might be able to do so. But I mean, if you look at certain industries, I mean, a typical restaurant, you can work from home, you've got to go to the restaurant and be able to serve people there.
This is interesting.
So it might work in some situations, but it won't necessarily work in other situations. So it's striking the balance really between the two.
All right, so it looks like there's some new law on the way, probably.
Well, the way to look at it really is that we will not get to a point where it becomes necessary. But obviously, what this has done is to raise the issue for both employers and employees to determine what if, I mean, today it's this corona, tomorrow what if it's Ebola, what if something else? So it's really a question of having something in place that can be activated to address the concerns of both employers and employees.
All right, interesting, and I'm sure that law students are busy trying to grapple with this as an assignment today, but thanks so much indeed, Ntate Maserumule, for joining us on the program.
My pleasure.